Welcome back, everyone, to another episode of Speaking Legally, where the legal meets the cultural. My name is Dr. Stacey N.C. Grant with Destiny Designers University, and I'm excited to be back again with our co-host for the show as we continue to look at what's happening in the world around us, especially in this COVID-19 reality, and of course, what we see happening with the cries for justice and equity. We know racism is not new, but we're dealing with the responses to it, and a lot of the information that we share will help you navigate these new normal waters that we're dealing in. So our co-hosts are here, Edward Pichardo Esquire and Royce Russell Esquire. Let them both say hello before we jump into the conversation today. So Ed, what do you have to say to the family?
Well, hello everyone. Thank you for joining us today at Speaking Legally. Once again, my name is Edward Pichardo, solo practitioner here in New York City with my partner Royce Russell. Hablamos español, Dominican American. Si tienen necesidades, vengan a nosotros.
Muchas
What's up,
gracias.
everybody? What's up, everybody out there? Based upon our preset conversation, we are going to spread some information that will help you understand that. And let me raise up. It says all, go the other way, good. So let me just do that again. All good. We will find out that all is not good when it comes down to the reforms that we have heard about so passionately in the media. And we will hear that maybe all things are starting to become good in reference to the indictment and the arrest and the call for justice in Atlanta. But right now, I'm sure Ed is getting ready to drop this hammer as we talked about before. What's that watered down Kool-Aid we about to talk about?
Okay.
Here we go.
We don't have top shelf liquor here anymore. We got the watered down version. Why don't you give the world the watered down version of the liquor that's going on here?
Well, before the watered down version, let me just say hello to some of our guests who are with us for every episode of Speaking Legally. We appreciate you, Sonia. Thank you, Sonia M. Tansley, for being here. Rolanda Lamont, how are you? Thank you for joining in the show. Make sure you share it out. Just click the share button. Let people know that Speaking Legally is back on every Wednesday, 4 p.m. Eastern Standard Time. So, yes, over to you, Ed, as you share, as Royce is putting the watered down version of what we're seeing passed in legislation.
Well, I believe he's referring to the Senate version of police reform. As many of you have heard, the Democrats in the House, where they are the majority, came out with the Justice and Policing Act of 2020, in some cases referred as the George Floyd Justice and Policing Act of 2020, which, touts a number of reforms. So in turn, the Senate came out with their own version, arguably watered down version of what the Democrats came out with. And the chief proponent of that bill is the Black Republican Tim Scott, backed by Lindsey Graham in the Senate.
Wait, Ed. You say that, and you say that with a smile. So we have to give our listeners the backdrop on who you're referring to. I think it's only appropriate. And you're using words that are, I'm taking homage to what Royce believes to be what he is talking. Either it is or it isn't. Now we can agree to disagree.
I just have to stir you up.
Version, or is it a watered down version? So my take is that it's watered down. It is not the same as we hear on NBC, ABC, CBS, BET on the commercial. And that is not getting publicized in the Daily News. I don't see no Daily News version of what is going on right now. So help me out.
All right, Royce. Can Ed just finish? You got it. All right. We're going to let him go through the version so we can finally get to the information. But to Royce's point, Ed, take it easy, Poppy. You got to break it down into small chunks. Not everybody knows how to litigate in the court of law and what these things actually mean. So let's take it step by step.
Okay, well, what I mean by watered down really is that there are a number of areas where, instead of actual reform of the law, we're talking about commissions to study, evaluate, and of course, when you create these commissions and they study, evaluate for the next year, 2 years, 3 years, then they come out with a report, and the question is whether or not any of those recommendations in that report actually get enacted into law. And as many of you probably understand, with time, the issue leaves the front page of the media. People start forgetting about it, and next thing nothing happens, and we're back to square one. Right now, in fact, even though both of these bills, the House and the Senate, have come out with legislative proposals, if you will, laws that they want enacted, that doesn't mean that they're going to be enacted. Because what happens is, for some of our viewers, if you don't understand, we basically have a system of government with different branches. You got the House of Representatives, and you got the Senate. Both fall under the Congress. And if one of those bodies comes out with legislation, in order for it to become law, the other body has to also pass the same law. They have to pass the same bill. It has to be textually identical. And then after each body passes the law, the legislation, then it goes to the president, who has to sign it. Now, they can override what's called a veto by the president, because the president has that power to say, listen, I'm not signing this, I'm going to veto this. And then the legislation has to go back for an override of that veto, which requires an overwhelming majority of the members of each body to pass the legislation. And that rarely happens, especially in our government, in each of our legislative bodies, where many of the majorities are razor thin or not overwhelming enough to override a presidential veto. So basically, we have a long way to go here. I don't know.
Let me ask you this, Ed. And so you mentioned presidential, and so we want to put it in the context of the state of New York. We're talking now the governor will have to make the final decision, and we also need to let our viewers know, since we're focusing on New York, right? I mean, we know protests have happened statewide, and various states are taking a variety of positions, but we're talking about New York here, and my understanding, given what I know about government and having made the trip up to Albany with you and with Dr. Grant, is that, is more black faces than any up in Albany at any given time right now. And I'm getting the sense, based upon what you're saying, is that they being African Americans in this particular position, in this particular time, looking at these particular reforms, may not be monolithic in their thinking. And so therefore we have different versions of the same thing that we want to happen, i.e. no chokeholds. That is a crime now. It was always prohibited in the police patrol guide, but now it's a crime. So one part of government is saying it's a crime. Is the other part of the government saying it's a crime, or are they saying something different? One is saying in 30 days we're going to get video footage, body cam. Is the other part of the government saying that, or they're saying something different? And so that is where we are holding this debate and having this conversation and watered down. The Daily News reports the tough talk, but then, as you said, it goes to another part of the government and certain things are subtracted, and you don't hear anything else about it in the news to know that what was said on Thursday actually passed on Saturday, or did something else pass? So please just go through the exact reforms or some of the documentation that you were talking about before.
Well, what I was referring to was on the federal government level, because New York passed its own reforms. The New York State Assembly and the New York State Senate, they were both able to come to an agreement on a bill. That bill went to the governor, and the governor signed it. So the reforms in New York State are law. What I was referring to was on the federal government level, the federal government, for law enforcement, on the federal level, and some of what they are trying to enact will also affect local law enforcement in some ways. That's what I was referring to. You have the Democrats are the majority in the House of Representatives. They came out with one bill. Then you have the Senate coming out with another bill. Now the Senate is controlled by the Republicans, right? So they're more conservative, right? Of course, politically and philosophically. So, quite naturally, on a progressive level, it's to be expected that the Democrats are going to come out with a bill that's stronger in its reforms. They want to end racial profiling, religious profiling, banning chokeholds, no-knock search warrants. They want to limit military equipment going to local police departments. I think you saw some of that with some of these protests that took place where the police are coming out with vehicles that look like tanks, like they're ready for, a war with a foreign country. And instead, they're trying to basically deal with their own citizens, which, some of us would agree is a bit bizarre.
How do you have a bill that bans racial profiling? How do you have a bill that bans that or bans religious profiling? I understand in reference to military equipment, but I just want to, dig a little deep on how do you have, now you could say it is illegal, but how do you actually ban it? And to the extent that you're talking about the federal, which is important, that's going to make the difference between whether a litigant like yourself or me or someone civilian in the street decides to take their wrongful arrest, their false arrest, their police brutality case into federal court as opposed to leaving it in the state court. And I think that's what some of our viewers really need to know, that if the federal government is going to play around or water down or not be in lock and step with the state, that may determine where you take your case if you go to sue. Am I correct?
Yes. In terms of the House, the House bill, it explicitly says no law enforcement agent or law enforcement agency shall engage in racial profiling. And in terms of enforcement, it allows the United States, the U.S. attorney, if you will, or an individual injured by racial profiling to enforce that law as part of a civil action for declaratory or injunctive relief filed in either state court or a district court in the federal district court. So explicitly, that's explicitly stated. And they also talk about the proof that's necessary that the routine or spontaneous investigatory activity had a disparate impact on individuals if a particular characteristic, meaning race, and will constitute prima facie evidence of a violation. It also allows for reasonable attorney's fees, expert fees as part of the attorney fees. So you have some language there that that litigators will benefit from in bringing lawsuits concerning racial profiling. I don't believe that the Senate bill is quite that explicit in that.
And so in proving a case in reference to racial profiling, right? I want to make sure our listeners understand this, is that that's a heavy burden, right? So it's not the one-off. It's not like I'm in my car, police stop me, they want to give me a ticket, but it turns out that the reason why they stopped me is not the real reason. My tail light is functioning or my brake light is functioning. Can that person then raise the racial profiling arm and file a claim in federal court, or does it have to be a little bit more systematic, like we saw with New Jersey state troopers and other state troopers, where there's actually, as you said, there's some type of research that's done with it, a gazillion-page report before it is validated in any courtroom?
Well, quite naturally, based on the wording, you're going to have to, I guess, look at, the data that comes out because, as we discussed last week on the state level, specifically here in New York State, there are enhanced reporting and data collection mandates. And so you're going to, as a litigator, you're going to collect that data, you're going to look at it, in terms of arrests of people of color. And if you see a pattern there and a disparate impact, then, I would imagine that's the data that you're going to use to support your civil action on behalf of your client or, clients, if you're talking about a class action, which you're probably going to talk about in this instance.
So for the average person that's trying to understand and decipher, how is it worth it? Like, how do you actually get to the point where you're litigating and defending? Royce mentioned it's a heavy burden. So what should the average listener think about if they're in one of those instances where they think they might have a case?
You want to go, Royce, or?
Well, I mean, I think, I'll go. In reference to that, the answer to that question is one, I mean, clearly this is not an issue where you can go pro se, and that means litigate yourself. You're going to have to hire an attorney. But what is going to give you the strength in the legs or the teeth in your lawsuit is the empirical data that shows study after study after study where there was racial profiling. And what I mean by a high burden is that the amount of data that you have to receive, depending upon what state you're in, really is determined how efficient the state is in collecting that data, right? So if you have a state that's like, you know what, we're going to do it sometimes, we're not going to do it all the time. Maybe we're not going to be as progressive as New York. And so therefore you're not progressive, then the data is not there. And all you have is your experience. And your experience might bring us right back to stage one where we're at right now, when you're talking about your experience. And the conservative courts are looking for data in order to rule on your case.
So let's pause there for a minute, because that sounds like an opportunity for the data collection. And who does the data collection? Is that something that's vetted by a governmental agency? Is it an independent agency? Like, who gets the data? Who's tracking how many of these cases are actually happening to create the data that you're using in court?
Well, first of all, you have the arrest. There's supposed to be a police report. Of course, the problem comes when you have a stop that doesn't result in arrest. No report is generated. So you have, people being stopped. No, nothing comes of it, no report. So therefore you have, no data. But then when you do have, an actual arrest and you do have a report, now the question is whether that report that is in the hands of the police department and then whether that then makes it to the courts and whether that gets collected, in a way where, it's not an issue of you independently having to ask for all of this data and having to comb through it versus the courts automatically compiling the data and then issuing, say, an annual, or semi-annual report or multi-annual report. So, that's what we're talking about in terms of data. And what Royce pointed out is you have to hope that the civil servants who are in charge of collecting this data are doing it faithfully. Sometimes, governments will have data reporting requirements and don't necessarily fulfill them because they will say, oh, well, we're underfunded, we don't have enough staff, we have yet to come up with a form, our computers are too old to collect that data. I mean, there's all sorts of reasons for why, this data may not be generated. And then if you have, say, foundations trying to say, well, just hand over the data and we'll sift through it. You got freedom of information requests, confidentiality issues. I mean, or whether this is a subject of investigation and therefore we can't turn it over. And not to mention cases where we're talking about minors and we can't give you that data because that data belongs to a minor. Or let's say we have an issue where the case resulted at the end in a dismissal, and so all of the documents are now supposed to be basically put away or done away with, so that the individual impacted there's nothing in the system showing that he or she was ever convicted, which is a beautiful outcome. But for purposes of data collection, that's somebody that's now going to be missing from that data, that was arrested because they were Black or Latino, was racially profiled. So there are a number of issues here in terms of the data, and that's
Richard said lost data.
That's what I think about. Yeah, a lot of data, and so that's what I mean by burden, right? The burden is sometimes not always legal in its format. It is just the burden of just being able to get the documentation. And what you referred to before, Ed, is what we call sealed cases. If they're minor, sometimes they're sealed. If it's dismissed, sometimes it's sealed. If you don't create a report, then it never hits the light of day. If somebody's not doing their job efficiently, even though they have the funding, then the information goes missing. And we all know people don't do their jobs every single day the way that they do it on a Friday or a Monday, right? So we know that. Now, that is definitely making the room, the light in the room, very dim, but we need to understand that, and we need to recognize that, and maybe we need to make sure that we organize ourselves to become part of the not-for-profit organizations or for-profit organizations to ensure that there are reports and data that is easily accessible to the average citizen and the average attorney.
Absolutely. And I just want to shout out Nathan. Thank you for coming back again to Speaking Legally. We appreciate you. Richard Russell II, we appreciate you being here as well. And hey, Stacey, thank you for joining in. Make sure you're sharing this series with those who can get not only content and information they can use if, God forbid, they have to go to court, but just be equipped to be able to have conversations intelligently about what's going on, because there's a lot of smoke and mirrors. The media sometimes spins the narrative, and you really need to learn how to think analytically for yourself and be able to decipher what's important, especially in our communities. So before you transition to the next layer of this, Ed, I think there's an opportunity that somebody will pick up, and that's the data collection. Richard talked about lost data. We know, like you both said, it might not see the light of day, but there could be someone looking to figure out a career path or looking to figure out how to develop a program or a nonprofit that can be solely focused on data collection for these disparities. We know we have tons of studies that are done in independent organizations. So I think that's something for someone, if that's your lane, to figure out how you can be an answer to the problem. And the problem is we don't have enough data all the time for attorneys like Ed and Royce to use when litigating these cases. So that's an opportunity for someone to create what doesn't exist and be able to have something that is traced and that is protected, and that we can't get some of these excuses that come up when we look at data collection as an issue for racial bias. And
let's hope that someone is someone of color, of the African diaspora, of the Latino diaspora, to come on in and say, here's an opportunity to make a career change, a career path, and since folks are giving out money and Black businesses matter, maybe they can give out money to those companies, startup companies, to start doing that type of work, because if we leave it up to the powers to be, we know that we're going to have a power outage, right? So we got to give it to the folks that really want the energy. And I want us to quickly move on to, because I know you got the sheets in front of you, I want us to quickly move on to qualified immunity. I think that's the big mountaintop. All the things that we're going to hit, that's the one. We always know that the Democrats and Republicans are going to forget to dot an I across the T. But this qualified immunity, boy, is it major, man. It's like, whoo, come on now. Come on.
Well, the text states, it's shown, and this is on the House bill, it shall not be a defense or immunity in any action brought under this section against a local law enforcement officer or in any action under any source of law against a federal investigative or law enforcement officer that the defendant was acting in good faith or that the defendant believed reasonably or otherwise that his or her conduct was lawful at the time when the conduct was committed. And so,
And who's the defendant?
The defendant meaning the law enforcement officer, because we're talking about cases where, the police officer is charged, and it's a refreshing new development, in these recent days that we're actually seeing police officers being charged, because for years we've been watching, these cases where these officers commit these egregious violations against citizens and they're not actually charged, or, the local prosecutor decides not to charge. If they do get charged, it doesn't, they don't get indicted and get off. So, and in many cases, one of the first things that officers will claim is that they were acting in good faith and that whatever happened, just happened, but that they were proceeding reasonably. And, this law, appears to, kind of move that off the table for them.
Can I put this in an example? I'm going to put this in an example. So this is what I call a good faith exception rule, right? This is qualified immunity. First of all, qualified immunity removes the accountability and the responsibility from the police officers. Accountability in that if you're able to use the defense of qualified immunity, therefore you will never have to pay out individually. You never have to be held accountable individually. So it's used as a shield to protect them against civil lawsuits. Now, here's a great example of what we call qualified immunity and the good faith exception. And in some cases, it should be implemented. In other cases, it should not. And I think the way we've seen it over the decades, it should not. You're walking down the alley, the person in the red jacket hits you over the head, takes the $20. You come out of the alley, you go to the police officer, you say, police officer, I just got robbed. You in the alley with a red jacket. The guy in the alley with the red jacket comes out, police officer immediately grabs him, beats him up, looks for the $20, can't find it. The guy in the red jacket says, I never robbed anybody. I don't have the $20. I don't know what you're talking about. And there's a video camera that's sitting right there that's playing in big screen. You need to go check that out right now. The police officer ignores that, continuing to abuse the person, and takes him in. The video camera reveals that the guy had nothing to do with it. So there's two prongs that happen. One prong is people say police are just there to make an arrest. They got a complaint from a citizen, and in good faith, the citizen said this happened. So in good faith, the police went and made the arrest. What more do you want them to do? Then it's the other side of the spectrum, which says the police should have looked at that camera right there, which was ready and available, before they continued with that arrest and abused that person. And then the police says, no matter what happened, I'm immune from both of this because I acted reasonably in good faith because I listened to a third party. And my job is not to investigate. My job is just to make an arrest. So you can't touch me. You can't sue me. You can't go into my pocket. And that's just a very simplistic example, but we can go and get more exaggerated where I thought he had a gun, so I shot at him. He reached in his pocket, and so I did this. I tased him. Or I thought I had my taser, but it was really my gun, and I fired that. The examples can go on that in the heat of the moment, quote unquote, reasonable people at a certain time can allege this defense. Correct?
Correct. I mean, it allows for you to, look at the conduct and really, break it down versus just this blanket immunity.
And so I think that's the reform that, or at least that part of what we want to try to reform is to remove that And I don't think anybody in Congress, I don't think no Supreme Court is ever going to remove that from law enforcement.
Well,
That's the point.
and I mean, the other issue here too, like you said, because we've talked about on the show about officers being incentivized to do the right thing if they start understanding that they could be individually liable versus the city being the one that's on the hook for their misconduct. Is that what you're directing this at too? And for litigators,
You got a
by the
question?
way, whether or not you're going to be able to get a nickel out of that officer if they don't have if you can't get at their homeowner's insurance policy, or if they don't have a pot to proverbially piss in, do you want to have to rely on being able to get redress from your client out of that individual officer or the city, which actually has the funds to pay out?
Well, I think two reasons why we'll never see any movement on this is one, is that in society we need police, right? And the only reason, and the only way you're going to get good people who may turn out not to be so good at the end of the day, in some cases, in small amount of cases, but in some cases, to become police officers and to become assistant district attorneys and others, is to say that, look, we're going to protect you. We know you have a low salary. We know this type of career is dangerous or job. So we're going to protect you from the lawsuits. And therefore you can do your job freely and uninhibited, right? Now, the flip side of that is that we do want some responsibility and we do want some accountability. So maybe there's not a change. Maybe there's an alteration. Maybe there's some accountability by way of 2%, 3%, losing some of the pension, but you still get a chance to use qualified immunity if and when it is appropriate. It is very, very tricky and complex. I would tell you as a litigant, and I'm sure you hold this true to yourself, is that you don't want to sue an individual. The individual is not where the money is, and anybody who's been injured is not going to get monetary justice from an individual who makes 32, 22, 18, maybe $42,000 a year. So we have to be careful for what we wish for.
And it's interesting because I believe I read a case several months ago where a city up in the New England area, one of those states up there, either Connecticut or Massachusetts, Vermont, where the city was able to get off because the particular law enforcement officer was shown to have acted intentionally. And so based on that intentional conduct, they were able to say, well, the conduct was intentional, therefore, we're not on the hook. We're only on the hook for something less than that. But if it's shown that the officer's conduct was intentional, then that officer is going to have to represent and defend themselves regarding the conduct, and the litigant in that case was left to sue only the officer, because normally when you sue the officer and you sue the municipality and or government body that employs that officer. And like Roy said, I'm pretty sure that wasn't a happy development for the plaintiff there, because how much money are you reasonably going to get out of that individual officer versus the city?
Especially when you ask them to be terminated. So now they're terminated. They have no money. You still, I mean, like, it becomes complex. I think, Dr. Grant, before you go on to the next point, I think what's important is that if we expand this a little bit, right? We expand it to qualified immunity when it comes down to assistant district attorneys and prosecutors. That's where I think qualified immunity really gets its teeth, because those actions could be considered more intentional than anything else, because it's not happening real time, real fast. The prosecutor decides to take the sheet that says I'm innocent, or that the guy was wearing a blue jacket, not a red jacket, and hide that piece of paper. Wow, that's big. Oh, I lost it from the file. We're just going to go with that when we find out years later that document was missing. How more intentional can you get? How can you even go under qualified immunity, which is extended, it's not called that, but it's extended to the public servants in those particular areas. I know if I do something wrong as an attorney, I get sanctioned and you come after me. How come they are shielded when we know we have prosecutory misconduct and malicious prosecution going on based upon these false arrests?
So let's pause right there, right? And I know you have a comment, but for everyone that's listening and just trying to follow along with Speaking Legally and really understanding in layman's terms what's happening, what can we do? There's so many marches and rallies and protests. I'm a part of one that we're having this Saturday. What should be the ask in these reforms and in how we change what exists? Because we have the lost data as an issue. We have, you saying that the district attorney should be held accountable as well with not withholding or losing information that could go in a file. So what can be done in your opinions? What should be lifted up as a part of the ask? Because everyone is now trying to segue from just marching, which is a part of it, and protesting to keep the pressure on. But I believe we need to have some clear ask, and we need to have some clear ways that we effectuate change. And if something has to be rebuilt, where do you start and how do you do it? So how can we share that with the audience?
Well, I think Royce hit on something in terms of that individual being liable at least for a percentage of what the plaintiff is asking for, in some, that they get hits, that some of, that they get hit somehow financially, not bear the entire burden of, say, the financial ask by the plaintiff, but at least to a small degree have to be responsible. For assistant district attorneys, you have your law license, and Royce mentioned, as a lawyer, if you do wrong or if you commit errors, in terms of, your practice, you get hit directly. You could lose your license and so forth. So, those are thoughts right there. And it's interesting that we're talking about this, and we learned today that the 3 individuals charged in the Ahmaud Arbery case indicted. In that case, you have some serious misconduct that has surfaced with respect to the various assistant district attorneys who handled that case. And in
I think Ed, I can't hear him. I think he froze.
Yeah, I think he froze.
But I know his thought. I think, in short, you got to have thinkers and thumpers, right? And I would like to think that I'm a thinker and a thumper at the same time.
Eruption in my signal.
And that's all right, Ed. And so sometimes when you have thinkers and thumpers, you need to divide the two. Thumpers out in the street. And I'm not saying you have to be one or the other. You can be both. The thinkers have to start now in really articulating what the ask is. And I think that all parties did not necessarily align themselves with one organization, one mission. You can have multiple missions. You can have an organization like the ECRB, the Elected Civilian Review Board, and you can have that same person belonging to the Justice Committee. One is looking at legislation up on the Hill. One is looking at statewide elections, and have a combination of things. Or while this is going on, expand what we mean by law enforcement, right? Law enforcement is not only police, it's corrections, it's also prosecutors. And understand that this platform has allowed you to expand it. Start thinking about, there's some financial people out here. There's some people I know that do pension and compensation work. Have those folks that do pension work start to try to dig a little bit, as one of our listeners has said. I think I saw a comment by Tony Reese. Get into that pension. Find out what those numbers are and how you can effectuate hitting that person in their pension by looking at the pension contract. Now, I would tell you right now, that's a heavy task. That's a high mountain to climb. But I think these are some of the asks that we should be looking at. And one of the first asks that I look at is stop with the rhetoric, my safety first. What are you telling the public as a police officer when you say my safety first? You're saying your safety last. And if I know my safety is last, then I know that I don't mean much to you. And I understand it's a delicate balance. But remember who you're speaking to. You're speaking to a mass of people. You're not speaking to everybody who's selling drugs or somebody who's committing a robbery. They know that your safety's first. And if they get caught, as they say, their ass is grass. But you serve a larger group of people that don't really want to hear that and don't want to think that when they're having a conversation with you, that your safety's first, and that means their safety last. That is some of the talk that we have to start to dispose of.
And I think that's something that you've brought up before, right? When we talk about how police show up in neighborhoods and the lack of community policing, and some people are trying to go back to that we need to push the line back and how you interact with law enforcement, that, you know, roughing you up or talking to you, that's still a problem because they're there to do a job to serve and protect. So if we're comfortable saying, oh, well, that's just how it is. So many people in our community are used to, oh, well, I get stopped all the time. Or, you know, they rough us up for no reason, or they do all of these behaviors that you've talked about. No. Let's start with pushing the needle back on what's appropriate behavior and what's not appropriate behavior, so that we can hopefully not even get to the escalation points that we've seen happen, of course, in the news with the lives of our brothers and sisters that are gone now, but that we can really say, this is how it should be done with crime intervention. We have people like Erica Ford with Life Camp that are out there doing intervention in the streets to de-escalate crime, to help address some of the issues that are happening. So it doesn't have to be the conventional way that we've seen policing, but that's a whole nother show to go into how police started in this country and what they were intended to do. So, you know, we're peeling back so many different layers, but in the real time, to what you mentioned in Cardiac Arrest in your book and what you talk about all the time, we need a certain level of humanity with how officers interact. If you do a crime, the police are there to stop you from that crime. But if you're innocent and they don't even know and they're just assuming because of the color of your skin, that's a problem. And if they're not interacting with any level of humanity, that's a problem. And that's how we've gotten to this point, and unfortunately is seeing what we see transpiring right now in 2020.
Yeah, I mean, with respect to that, I mean, the discussion has been that we need to change the mentality of the police officers from one of warrior to one of guardian. You know, the idea that, no, you're not here to fight a war. What you're here to guard, safeguard the population that you've been entrusted with protecting. And when you take on that mentality, that should also affect your interactions with citizens, so that when you see these officers and you speak to them, they're not treating you in a way where you don't have a right to even address them. You know, so, you know, that's been the big issue. But, you know, I wanted to bring up a point, and I wanted to get your take on this, Royce, is the ban on no-knock search warrants, and what exactly is a no-knock search warrant and how it led to the death of Breonna Taylor. This idea that officers can just rush into a home without announcing, you know, giving notice to the homeowner of the occupant that they're there and what they're there for, and that, you know, that they have a warrant and would like to enter. I mean, what are your thoughts on that?
Well, let me just, I'm gonna go back a little bit in reference to when we're talking about qualified immunity in relations to the community.
Yeah.
I would gather that, and I've seen and I've litigated a bunch of these lawsuits, that when the police officer comes and arrests a woman who the store owner says she stole something, and the woman is saying, I didn't steal anything, here go my receipt, look at my receipt, ask for their footage, that there's nothing in the patrol guide that prevents them from being thinkers. There's nothing in the patrol guide that says you can't take the extra 15, 20 minutes. Now, if we're talking economics and we want to be cynical and we want to say that they're just going to make the arrest to get the overtime, well, the same amount of hours are being spent if you just say, all right, ma'am, I'm sorry, we got to hold you here. Let me see the receipt. Yeah, it does look like you purchased all that. All that is in your bag. All right. Hey, So say liquor store. Let me see the footage. I don't see what you see. All right. Explain to the woman. All right, we're gonna have to let you go, or explain to the person at call. We're gonna have to let her go, or explain to the person that's being arrested. Look, I saw the same thing you saw, man. I don't see you there. I see you got the receipt. However, my job is that I have to arrest you, and the DA has to make that decision going forward. Now, you may not avoid a lawsuit, but you might avoid, like, all right, I see what your job is. I don't really condone it, don't consent to it, and I am pissed off, but you're explaining it to me, and now I'm looking for the next entity to do the right thing. And then at the end of the day, if they let you go out the back door, then you can say, all right, they did the right thing. I mean, that is something that you got to give us something. Now, in reference to the no knock, this whole theory of no knock came about in that you don't want the spoliation, you don't want anyone to destroy the evidence, right? So if you're talking about drugs, you don't want someone to throw the drugs, flush the drugs down the toilet, or water it down, or throw the gun out the window, or throw the drugs out the window. So they created in part and parcel the no knock warrant. We're going to catch you by surprise. We're not going to do and say we're the police, and this way you can, whip up, try to flush the cocaine or smoke all the marijuana by the time they come in, which is probably impossible if you're going in there to do a no knock on the type of drugs you're looking to get. So the police want to have an element of surprise. Now, what the thinkers forgot, because they weren't thinking at the time, is that if you have states where the Second Amendment to carry a firearm is number one, uno, and you carry a firearm, and you live in an area where burglaries maybe are not rampant, but happens. You live in an area where maybe robberies don't happen all the time, but they do happen. Or you live in an area where there's an uptick of burglaries, and all the other times there's never been a burglary, but now there's an uptick in burglaries. And you have police officers with no knock, which I'm litigating at least 3 or 4 of them right now. And they burst in that front door. A person who has the Second Amendment right is going to reach for their gun, going to protect their home, going to do what they got to do, and you coming in there ready, locked, and loaded, and you're going to take someone down, and you're going in there fast and swift, and you're not even thinking about the other side. So you have to think about the other side when you're stopping someone in the middle of the night, and they're African American, Latino, or the African diaspora. You have to think about what they may have gone through and what they go through in order to really effectuate your job. That's the humanity that you talk about, Dr. Grant. That is the wherewithal that you talk about, Ed. You can't work in a vacuum and isolate yourself and think that it's a one-off. So they went in, and you know what happened. It led to her death, right? She had a gun, she moved for a gun. The mindset of what was going on in her neighborhood at the time was justifiable. But I've seen where they had no knock warrants where kids were just in the household, and the parents weren't there. And the kids were held at gunpoint, a 13 and a 2-year-old. Come on, man.
Yeah, I mean, frankly, I believe that the spoliation of evidence concern is outweighed by the dangers to the person, the occupant in the home, and even to the officers themselves. Because, like you mentioned, if the occupant is armed and that officer comes in, the first one coming through the door is the one who could catch the lethal bullet. And you now have a situation where you have the person inside injured as well as the officers. I just think that it's a practice that needs to be eliminated, period.
I mean, look, and here we go again with the thinking part, right? If you're tracking them, if you're surveilling them, if you're doing your job, you're going to get them. It's not you're going to get it. I see it in the projects without surveillance. What they have been doing for a long time, instead of letting the local prosecutor handle cases, that I've seen this in the Bronx in particular, what they'll do is that they'll go up to a project and they'll do 40, 50 hand-to-hands, 60 hand-to-hands. And then when they arrest you for federal charges, because now you have so many hand-to-hands, it's unbearable to even think that you're going to wind up in state court. Instead of, you get the one hand-to-hand, off the state court it is, and then we can move on. So this ideology, like you said, the evidence is going to destroy itself is BS, and it's used to the detriment of our community and the embetterment. And here we are, we have a death because of it.
And, you know, of course, our show goes way too fast with just breaking down these issues. And we hope that you appreciate the dialogue, the information, and the knowledge that'll allow you to be better equipped, because we have a lot of, I call them sidewalk attorneys that like to tell people what to do and how the law works. But here you have two individuals who do this every day for over 2 decades with the right information. They're in the courts fighting these cases, representing our community, that you could reach out and know that someone that looks like you, that speaks like you, habla español, has an opportunity to be able to advocate for your rights, but then also that you can be knowledgeable about what's going on. So there's a lot of work to be done. This is not a sprint. This is a marathon. We're in it for the long haul. We know we have a fever pitch of activity and response that's happening, but we can't use this time and lose the momentum. So we have to be able to equip ourselves with the knowledge. So thank you, Shawnee. Thank you, Richard, for being here. Thank you, Andrew, for tuning in. Thank you, Tony. We appreciate you, Stacy, Nathan, Top Secret Tree. We appreciate the fact that you've tuned in to not only get the information, but share this information with your audiences, and know that Speaking Legally is where the legal meets the cultural. We're here every Wednesday, 4 p.m. Eastern Standard Time, and we'll continue to dissect what's happening in real time in the world, as well as give you information from these two attorneys who are passionate about helping our communities survive these atrocities and be able to really work through how we can make this world better, because it's going to take an overhaul of the systemic ways in which we see racism show up in a variety of platforms. But here we talk about the legal aspect.
Well, Dr. Grant, let me ask you this question. So we have said that, you know, it's going to take an overhaul. There were elections that happened in New York City yesterday. What happened? Who won? Who won what? Can you fill in the viewers of who took who place in the shoulders of reform, or was it the same old, same old?
Well, you know, I haven't gone through all of the lists. I know locally who won in these primary elections that have been a part of city council. We have a Donovan Richards, who was running for Queensborough president out here in Queens, Clyde Bennell for his seat in the assembly, our state senators that have been at the forefront. Alicia Hyman is another assemblywoman. So we have people who have kept their seats. I haven't really looked, to be quite honest, and see what upsets might have happened in the primaries, because I've been so busy focusing on the other aspect of advocacy in the community and delivering. But I think that's a good one for next week's show, because we're literally wrapping up right now. But Mr. Russell, I think we can talk about that. Who actually won these seats? And let's analyze what they've done and what they've advocated for when it comes to police reforms. That's a very good idea. Shawnee G said, good question. So yeah, to be continued, since we're coming down to the end of the show today. And Ed is going to come back in for a minute so that both of you can give your final comments. But I think it's important to note that voting is important, and it's an opportunity for us to make sure the right people are representing us in local government, not just federally, seeing what's happening down on 1600 Pennsylvania. We already know what we need to do there, but what's happening on the state level and the local level, which is important. So I'm going to go ahead, Mr. Russell, and make sure that we look at that across the board. That's our homework for Speaking Legally.
Well, I know Ed already got the answers, so we'll save it for next time. I know Ed got all the answers. Who won whatever race in New York, Bronx, Harlem, or whether Brother Jamal won or whether Michael Blake won. I mean, look, we'll talk about that next week, but I know he already got the answers, because that's the playing field. Look at, he already ready to go.
He's excited about it, but we don't have time in the show to break down what that means, because it's not only who won the election, but what that means potentially coming into November, and what that means for each community. Because while New York City, we have a lot in common, there are very specific issues in each borough. that need to be addressed, and that we need the right people in position and in place to advocate for our rights. So stay tuned, everyone. Speaking Legally, we'll be back again next week, Wednesday, 4 p.m. Eastern Standard Time. But I'm going to let our two co-hosts give their final remarks.
Get the camera.
Give their final remarks before we wrap up today. We'll start with you, Ed Pichardo, Esquire. What do you want to say in closing to our audience?
Well, next week we'll talk about the winners, and it'll be appropriate because there's still a number of absentee ballots that need to be counted. So even though you have many candidates leading by, large percentage points, those absentee ballots still need to be counted, and they should be counted by the time we talk about it next week. So in closing, I'd just like to say to the audience, thank you for listening to us today. And if you need to get in touch with me for any of your legal matters, I can be reached at 718-514-9099, 718-514-9099, www.lawofficeofedwardpichardo.com. See you next week. Thank you. Bye.
See you guys next week. Royce Russell signing off. I know I saw you looking at your watch, Dr. Grant, so I'm signing off real quick. 718-785-8890, 718-785-8890, www.roycerussellesq.com. So until next week, Wednesday, everybody take care. Be well.
Thank you, everyone, and thank you for tuning in.